Hello and welcome to Spardha Lines, your one-stop destination for civil services preparation, UPSC, KPSC and other relevant government examinations. In today's Hindu analysis, we will take up some of the important articles which are important from GS paper 1, GS paper 2, GS 3 perspective, and this is important both from the preliminary as well as the mains examination point of view. Let us try and understand some of the important articles. Let's look into the first article. The first article is speaking about one of the initiatives taken by the Government of India, and the Government of India has come up with a scheme called as the PM Vishwakarma scheme. What is this scheme all about? This happens to be a scheme which is able to empower those from the traditional artisan as well as the craftsmen. What is the need of this particular scheme? When you look at these sections of the people, they want to get economically empowered. They put in their hard work as well, but they do not have the necessary resources at their disposal. What is the main objective of this? The main objective is to ensure that these resources are provided to the people. For example, they require a lot of money finances. These finances will be provided by this particular scheme, and at the same time skill enhancement that is required for this section of the people will also be provided by the PM Vishwakarma scheme. So this article here is speaking about the PM Vishwakarma scheme, which happens to be a central sector scheme. What is this central sector scheme? Whenever we consider the scheme, there are two types of schemes. One is what is called as the central sector scheme. The other is what is called as centrally sponsored scheme. A central sector scheme basically means this is a scheme of the central government where all the investments and the funding will be made by the central government. So what is this scheme all about? This happens to be a central sector scheme to support traditional artisans and craftsmen at rural and the urban India. So remember, it is both at the rural level as well as at the urban level. This can be very important pointer from the preliminary examination point of view. So do note, it is a central sector scheme, which means the entire funding investments will be made by the central government. It has a financial outlay of about 13,000 crores. There will be 18 traditional trades to be covered in the first instance. Artisans and craftsmen will be provided recognition through the PM Vishwakarma certificate as well as the ID card. So how will they be recognized? What they'll be issued is a certificate as well as the ID card. A credit support would be given as much as 1 lakh in the first tranche and 2 lakhs with second tranche, and this will be a concessional interest rate of 5%. So when we look at the interest rate when it comes to the normal circumstances will be quite huge as well. But in this particular case, it is given at a very small interest rate. So they would be able to get the money and at the same time use it for their upgradation on the economic prosperity, and the interest that they are supposed to pay is very meager in nature. This will also provide skill upgradation, toolkit incentive for the digital transactions as well as the marketing support. So apart from providing the money to these people, what they would also be provided is skill upgradation, toolkit incentive for digital transactions, so on and so forth. So the PM Vishwakarma scheme is one of the initiatives of the Government of India, basically to empower a certain section of traditional artisans as well as the craft persons. Who are the people who are involved in it? Who will be covered under this particular program? The people who would be covered under this program includes carpenters, bootmakers, armorers, blacksmith, hammer and toolkit maker, locksmith, goldsmith, putter, sculptor, cobbler, mason, basket mat makers, oil and lamp makers, toy makers, barbers, garland makers, washermen, tailor as well as the fishing net maker. What are the other important aspects covered under this particular scheme? Under this scheme, what they will also try to infuse is the Guru Shishya parampara, or the family based practice of the traditional skills. What exactly happens in India? In India, what we had was the Guru Shishya parampara, which means you had the guru who happens to be the teacher. The same was also the knowledge that is transferred from the guru to the shishya, that is his disciple or the student. So this will not be provided to other section of the people because of the historical reasons. So basically this will have a Guru Shishya Parampara or a family based practice. So in order to promote them, the aim of this particular program is to support such people. This will not only improve the quality of such a product, but then this will ultimately provide the reach to such products as well as services. As we initially discussed, these are the small section of people. So they make a particular product. This particular product is only provided to the family members. The knowledge transfer happens to the family members. So the family members will start building this particular product, but they do not know how to market this particular product. They do not know how to make this service provide to multiple sections of the people. So marketing as a tool will also be assisted to these sections of the people. So on one side, they are provided the money that is required and all other assistance so that they can improvise on their product and ultimately deliver in the market. As of now, the major hurdle and an impediment for them is they are creating this particular product, but how are they going to sell this particular product? Who are the buyers of this particular product? Do you know about it? Do I know about it? Do the society knows about it? No, not much people. So marketing will also be provided by the government. So the entrepreneurship spirit will also be pushed in with respect to these people, ultimately improving the quality. And finally, this will also further improvise on the India's rich cultural heritage. So all those areas where India only had expertise, this will now be exported to multiple areas. That is, the product will be developed by the Indian artisans and this will be sold in couple of places in and around the world. So the interest rate will be nominally charged and as a result, they would be able to pay back. So the major advantage would be skill enhancement. So these people would be provided the skill set as well. They would also teach their fellow pals as well. They will also be providing it to the family members as well. So apart from the financial incentives given to the people, these people would also be provided skill enhancement, more empowerment, and ultimately they would be able to sell their product in the market. And as we discussed, when it comes to the funding, it happens to be a central sector scheme. It will be entirely sponsored by the central government, but it is also making a request to the state governments that, dear state governments, we have come up with this particular scheme, but we need your support. So it is also making a request to the state governments to empower and then come together so that these people can ultimately be empowered. Under this particular scheme, how is the registration process? Under the scheme, common service centers will be set up in rural areas for registrations and beneficiaries will be finalized at the district level by the state governments. So the registration can be done at the common service centers in the rural level. There are some challenges when it comes to this particular program. What are these challenges? One is lack of patronage. What is this lack of patronage? Let's say, for example, I'm coming up with a product. I take this product very personally because this has been given to me by my guru, or this particular product has been taught to me by my forefathers, grandfather, father, so on and so forth. And ultimately, I become a particular person who happens to know in and about this particular product. I release this product into the market, but who is going to buy this product? Now I am also provided loans as well. The loans is provided at a very low interest rate as well. What if the loans that I have taken, I have released my product into the market, there is no one else to buy, there is lack of patronage, there is no one section of the people who are buying this particular product, and as a result I would have taken debt, I would have taken loan as well. So if my product is not being sold in the market, I would also have a lot of credit that I would have taken, which means it is not only me who is suffering. If this particular product is not sold, my family could also come under a lot of debt as well. So the problem is there is lack of patronage. There has to be one section of the people who are buying it. The government has to procure it, or a certain section of the people have to procure it. When this is not being procured by a single section or by a group of people continuously over a period of time, this could result in a loss to the person who is creating that product, because he would have taken the credit, he would have taken the money, and now he is not able to pay back because his products are not being sold. And as a result of which, this person not only suffers, his family also suffers, and they have to repay back the debt. That is the major cause of problem. There is also undervaluation of their economic output. Let's say, for example, they offer a particular good or they offer a service as well. How is this going to be quantified? How is this product going to be attached with the price tag? So even if the input cost is, let's say hypothetically, is about 100 rupees, what if the output that I'm giving, the product that I'm giving, is costing very less and not able to make the profits? So I would have invested a certain amount of money, but I'm not generating any profits from it. There is lack of marketing as well. There are new markets that is not generated in this particular case. The government says that we will provide the new market in the picture, but how are you going to do it? What are the measures that you have taken? What are the steps that you have been taking? Have you been constantly coming up with marketing strategies for the same? As of now, this is still unclear. As of now, this is still vague as well. So how are you going to produce this particular product and release this particular product into the market? So there are new markets that are not coming up, and at the same time, there is undervaluation of this particular product. And as a result, what could happen? This is a product which comes from the Guru Shishya parampara. So it is only few people who would know what this product or the service is, or this particular product is basically one with the family support. So it is the father who teaches the son, it is the grandfather who teaches the father, father to the son, so on and so forth. So if people have taken debt, and if it is only within a particular family, it is only that family which is continuing to perform this particular good or the services, when they are not able to pay back the debt, this family, it does not have any other skill set, the individual will not have any other skill set, and ultimately this person from a particular caste will continue to stay in the same caste, performing the same kind of work, and he will not be empowered in a future generation. So this will end up leaving the next generation willy-nilly stuck for perpetuity in these traditional low-paying trades. So what we have to understand is we have to overcome all these issues and ultimately bring a new change. Yes, the intent of this particular program is nowhere good. It is absolutely good. There are chances that have been taken by the government. It is wanting to provide the financial support. It is also wanting to enhance the skill of these people, and it is also providing interest at a very nominal rate as well. This is absolutely good. However, there are some reasonable challenges and concerns that the author brings in. If these challenges can be addressed, if new markets can be explored, if new price tag can be given to this people and profits can be generated with enough amount of marketing, then this will be a very astonishing scheme, is what is being promoted under this article. So if we are able to address all these challenges, we would be able to ensure that it ultimately serves those people for whom this is envisioned and envisaged, is what is this article all about. Now let's look into the next article. This article says, is there a need to replace the IPC, the CRPC and the Evidence Act? This article here is speaking about 3 new legislations that have been introduced by the Government of India. So a bill has been proposed. It was recently proposed in the Parliament. Now it will go to the Parliamentary Standing Committee. They will scrutinize the sections after sections, and ultimately they will also suggest the government as well. If the government feels that it needs to be introduced and implemented, then they will also implement the same. If there are large number of changes that needs to be introduced, then they may come up with a new bill as well. So when it comes to these legislations, what is the government trying to say? The government is trying to say that we have the Indian Penal Code, we have the CRPC and the Indian Evidence Act. When was it designed? It was in 1860. The core of the CRPC though was designed in 1973. The original act was in 1898. Then you also have the Indian Evidence Act of 1872. So all these laws that have been made have the colonial imprint, which means it was under the British administration. The idea was to ensure that punishment is given, reformative justice is not taken into picture, but in this particular case, in order to ensure that justice is provided, victims' concern are also taken into picture and they meet the modern day exigencies, the government has come up with these new legislations. So we have discussed this in an elaborate video recently. We will not be taking up this, but what we are trying to discuss in today's article is there a need to actually replace the CRPC, IPC and the Evidence Act? Are the changes that are already introduced through various amendments not enough or not? not. So what we will try and understand is some of the advantages if it is introduced and some of the concerns as well as the challenges that is emanating from this particular act. So first let's look at some of the advantages. We've already had an elaborate discussion. The video for the same is already put up on our YouTube channel. What we will do is stick only to the advantages and some of the concerns that have been voiced by the authors in this particular case. So what are the advantages or what are the arguments which says that yes, we need to replace IPC, CRPC and the Indian Evidence Act. For example, in the CPC, what the author says, for example, in the IPC, what the author says is that there are 175 sections that have been amended, 8 new sections that have been added, 22 sections have been repealed to generate the Bharatiya Nyaya Sanhita bill. So the point of emphasis is 175 sections have been amended. So if you go on amending the existing act, it will become a bulky exercise. As I previously told you, there is a bill. This particular bill goes to the Parliamentary Standing Committee. If the Parliamentary Standing Committee makes a suggestion that there are very small number of changes, what the government can do is introduce those changes into the existing bill. But what if the number of changes are too huge in nature? In that case, they have to come up with a new bill in itself. For example, the Data Protection Bill, we had the Sri Krishna Committee which was appointed. The Sri Krishna Committee looked into the data protection laws of multiple countries in and around the world and they came up with a proposal. This draft proposal was ultimately sent to the parliament as well. The parliament did come up with the suggestions, but they were too huge in number. So what did the government do? The government introduced a new legislation in itself. So similarly, when the number of changes that has to be incorporated is far in excess, why come up with the amendments after amendments? Instead come up with a new legislation, which is what the government has done. This happens to be a law which has come up by the British. It was for those times where the relationship between the British as well as the people existing in the community is basically about the ruler and the one who is getting ruled. But now we have sought the independence, we have the independence, there is no such relationship. All that we want is a beautiful relationship between the ruled as well as the governed as well. So in this particular backdrop, instead of amending many, let's come up with a new one, and that is why there were 175 sections which have been amended. So that is why a new legislation is the requirement. So this happens to be an advantage. It is good that organized crimes have been defined. Once the trial concludes, the judgment has to be given within 30 days and only allowed 2 judgments and only 2 adjournments are allowed. So what is organized crime? For the first time has been defined in the Indian Penal Code, and when such a trial has taken place, the judgment has to be delivered within 30 days. So there is expedition of this particular process and the judgment will be delivered as soon as possible in the prescribed timeline. There are some provisions that say if you cannot finish the trial within 6 months in petty offences, then that person will not be tried, but this pertains only to the petty offences and has not been linked with serious offences. So if a person has committed a petty offence, let's say a crime which has less than 1 year of imprisonment or 6 months of imprisonment, 3 months of imprisonment, so on and so forth. So these are petty offences. So for such petty offences, if they are not able to decide on this case within a restricted period, in that case this will not be considered as a crime. That is, the person will not be tried. It is a crime, but he will not be tried and he will also be released. These are some of, and then there is also community service that has been proposed for the first time in the new bill as well. This is a community service which is practiced in couple of countries like United States of America. So offense is committed, so this person, in order to ensure that he is released, he has to perform community service. Such new things are also being proposed in the new legislations. So yes, we have to bring these changes is one set of argument. The other set of argument is with respect to these changes should not be introduced. Why this should not be introduced? When you consider a law gets interpreted over a period of time. So there is legislative intent. The legislature come up with the law, and who makes the interpretation of these laws? It is the judiciary. So when the judiciary comes up with the judgment, what it is also setting is a precedent. What is this precedent? A precedent is an act of the judiciary where such an act or a judgment or a decree passed by the judiciary will ultimately used for the future judgments. So in so and so case, so and so circumstances were present, and as a result so and so circumstances have arisen now. So the same judgment holds even for the present circumstances as well as the case. So there is precedence, there is jurisprudence, there are case laws. So since 1860 and immediately after 1947, what we have developed is large scale jurisprudence with respect to criminal acts, with respect to the precedents established by the court of law. Now if you are enabling or coming up with a new legislation, what should happen to these precedents? If there is a new legislation, this precedence is not taken into consideration. So this is a cumbersome process, is the first argument. The second argument is in terms of the detention. What is this detention? There are two types of detention. One is what is called as punitive detention. The other is what is called as preventive detention. What is punitive detention? A person has committed a crime. He goes through this entire process of trial as well. And once the trial is concluded, he will be imposed with a penalty. So he will be convicted and he will be thrown behind bars. So the conviction happens and it is proved that this person who is guilty of this particular offense has been proved by the prosecution. So he will be thrown behind bars. This is punitive detention. What we also have is preventive detention. So in preventive detention, a person might not have committed a crime, but there is an apprehension, there is a fear that a person might commit an offense in the near future. So in order to prevent this person from committing an offense in the near future, he is restricted from moving out and he is also arrested and retained in the police stations for a couple of days. What is the issue here? In Scotland, the amount of time for which you can keep a person in detention without bringing charges against them is only 6 hours. However, in our country, it was 60 days. The new bill proposes it to be 90 days. So it seems we are going in the opposite direction, and the new CRPC seems to have formalized this principle not just for acts related to terrorism, but even for general laws like IPC. So this is the major issue, says the author. The new CRPC also gives a lot of discretionary powers to the police, like the right to handcuff. Right to handcuff has already been discussed in couple of judgments in India. For example, the DK Basu case, and we also have the Kedarnath Singh judgment as well. These have clearly said that handcuffing should not be done and should be done in exceptional circumstances like terrorism, so on and so forth. But in this case, the author says that despite these judgments clearly laying out that handcuffing should not have happened, should happen only in exceptional circumstances, now that discretionary powers have been given to police, they will continue to exercise this right to handcuffing, says the author. Substantial sections have been jumbled, which has caused some ambiguity and confusion. When it comes to the terrorist acts, the bill replaces sedition with subversive activities, which makes it vague and broad. Terrorist activities have also already been defined under the new bills, even though we have legislation like Unlawful Activities Prevention Act. So we have what is called as general laws. We also have something called as special laws. What are general laws? For example, the Indian Penal Code happens to be a general law. What is a special law? A special law will only look at a specific idea or a provision. For example, we have the NDPS Act, narcotics, drugs, so on and so forth. So this act is only with respect to preventing drug terrorism in the country, drug issues in the country. We also have the UAPA, which is Unlawful Activities Prevention Act, which is only to do with terrorism. So what are special laws? Special laws are those laws which are very specific to a specific provision or an item. We have special laws. If you have a special law, if you also have a general law, if the special law has a provision, this special law's provision will take precedence over the general law. So while we already had a special law which was defining which was actually giving an imprint of what terrorism is all about, it was regulating about terrorism. Why is this being introduced into the general law? As we just discussed, in special law, it will take precedence over the general law. General law happens to be IPC, special law happens to be the UAPA or the NDPS. So when these laws already have the precedent, why introduce the same, create multiple layers with respect to terrorism, is another major question. And when it comes to IPC, if I ask you who is a 420, you would have seen in movies as well, and we would also have, and interactions with our near dear ones, that you are 420, so on and so forth. So who is a 420? A 420 is a person who's committing cheating, so on and so forth. We also know for the fact that if we are speaking about 302, what is a 302? 302 is an offense dealing with murder. So we have got used to the IPC sections like 302 or 420, so on and so forth, because it has been in the public memory for a very long time. So by now, changing this numerical figure as well as the section, how are we going to document this entire process? So the National Crime Records Bureau and the criminal tracking system already would have got used to it. So the system would have already understood how to document it. But now with the new legislation, this will also become a cumbersome process. The courts had already decriminalized consensual sex between adult gay men under section 377 of the Indian Penal Code. This has now been completely removed. The problem here is, when this particular section is removed under the new legislation, what was decriminalized? Decriminalization was with respect to only consensual sex. But in this particular case, what if the consent is not taken? What if it is forced? If this is completely removed from the new legislation, we are not taking into the picture the forced sex between adult gay men. That could also be problematic, says this article. So these are some of the concerns that have been voiced under this article. So remember, we've already discussed a detailed analysis for the same video. We already have it in our YouTube channel, but now we are restricting ourselves to what has been discussed in this article. Now let's look into the next article. This article here is speaking about registration of births and deaths. When we speak about registration of the births and deaths, we have one of the important laws which was designed in 1969. So it is the Registration of Birth and Death Act of 1969, which is currently there. But the government has come up with a new legislation which is to do with the Registration of the Births and Death Amendment Bill of 2023. So this particular bill will become an act because it has already been given the consent. What we have to understand is what are the provisions of this legislation and couple of concerns voiced by the author. When you look at registration of birth and death, this happens to be in the concurrent list. So who would be able to make the laws? It is the union government which would be able to make the laws. It is also the state government which would be able to make the laws. So union government as well as the state government would be able to make the laws. As part of the assignment, you have to put on the comment section in which entry item it is present in the concurrent list. Please put it on the comment section. Now you have the concurrent list. One of the things about concurrent list is, let's say the central government is making the law, the state government is also making the law. What if there is a conflict between the law made by the state government as well as the law made by the union government? In this case, the law made by the union government will supersede over the law made by the state government. So if there is conflict, both have introduced legislations, and if there is trigger point, there is conflict between tussle between the union government and the state government with respect to one of the sections. In that case, whatever has been made by the union government, that will hold, and whatever is being made by the state government, that will get dissolved. So the precedence is in favor of the union government. However, there is an exception to this. What if the state government has made a proposal to the president? The president has considered this particular proposal. The proposal has been accepted by the president. In that case, whatever has been made by the state government, that will hold. So if there is a conflict, it is the union government's proposal which will hold good. But if the state government has taken the permission from the president, and if the president gives permission to it, then whatever the state government says, whatever is its legislation, the same will hold water. What are the provisions of this particular legislation? When we look at the bill, it makes it registry for the Registrar General of India to maintain a national level database of births and deaths, and the Chief Registrar of the births and deaths in every state is required to maintain a state level database. So what do we understand by this? That we will have a national database, we will also have a state database. So the national database will be taken up by the Registrar General of India. As part of the assignment, please put on the comment section under which ministry does the National Registrar General of India come. Which ministry? Is it the Ministry of Home Affairs? Is it the Ministry of Social Welfare? Which ministry does it belong to? Is what you have to put on the comment section. So at the national level, we will have the Registrar General of India who will maintain this particular database, and at the state level, what we will have is the Chief Registrar of Birth and Deaths in every state. They will have their own databases, and from the data that is collected certificate from the states, this will also be taken up by the Registrar General of India. So the states will have their own independent databases. The national body will take this data and also put it in the larger database. These databases are to provide information to update National Population Register, Aadhaar database, electoral rolls, ration card, passport and other databases. Aadhaar details of parents and informants are also required as well, and the bill adds that in case of birth, the specified persons shall also provide the Aadhaar number of parents and informants. This provision also applies to jailer in case of birth. Let's say for example a birth happens in jail, the jailer Aadhaar will also have to be linked. Manager of a hotel or lodge in case of birth in such a place. So if the birthplace takes place in a hotel, in a place where they are residing, so the manager of a hotel will also have to provide his Aadhaar details tagged to it. Further, it expands the list of specified persons to include adoptive parents for non-institutional adoption, biological parent for births through surrogacy, the parent in case of birth of a child to a single parent. These people's Aadhaar will have to be integrated with that child. Then what they need to have is a connecting database. The bill states that the national database may be available to other authorities preparing or maintaining other database. So since it is a central repository, it can be used for other section of the authorities as well. This includes database for the population register, electoral roll, ration card, any other national databases. Since it is a central repository, in case there are commissions or authorities or bodies who are making use for the public services like electoral rolls, ration card, their names can also be picked up from this database. Use of birth certificate. The bill requires use of birth and death certificate to prove the data and place of birth for persons born. The information will be used for purposes including admission of an educational institution, preparation of voter list, appointment to a government post, any other purpose. We will also look at concerns that is emanating from this. Point to be noted is that we have a person who is given his Aadhaar, that is a doctor, it can be a jailer or a manager of a hotel. This person's Aadhaar will be tagged to a person who is born in that place. Added to it, this data that is collected will also be used for admission to an educational institution, for the preparation of voter list and appointment to a government post as well. What are the concerns that are emanating with it? We will continue with this particular lecture eventually and understand that. Appeal process. Any person aggrieved by the action or order of the registrar or district registrar may appeal to the district registrar or chief registrar respectively. Such an appeal must be made within 30 days from receipt of such action or order. The district registrar or chief registrar must give their decision within 90 days from the date of appeal. These are some of the important provisions. So as we discussed, what we will look at is now concerns associated with it. Now this certificate that is given by this body, what if a person does not have the birth certificate? What if the Aadhaar is not tagged to that person's number? In that case, he will be denied the right to education. So it says that this birth certificate is required for the right to education, but denying admission to school to a child without a birth certificate may violate the fundamental right to education under Article 21A. So on one side, you are saying that this is compulsory, it is mandatory, but if the person does not possess the birth certificate, are we not going against the constitutional paradigm? Are we not going against the fundamental rights? Are we not going against Article 21A, which is envisaging providing education to the children? So it is direct conflict with Article 21A. Then we have Article 326, which guarantees that every citizen above the age of 18 years has the right to vote except for some circumstances like disqualification due to non-residence, being of unsound mind, so on and so forth. But the absence of the birth certificate for age proof does not fall within the mentioned disqualification. So what if a person does not have the data, and if this data, that is the birth certificate, is not provided, is he not entitled to vote? And do note, right to vote is a constitutional right. In fact, there was one of the questions that was asked in the UPSC, I think in 2017 or in 16, there was a question asked, right to vote, is it a statutory right, is it a constitutional right? And there were many other options as well. but UPSC gave the answer as a constitutional right. So remember, right to vote is a constitutional right. This has also been reiterated by the Supreme Court in couple of judgments. So if there is a question which asks you, is right to vote a statutory right, constitutional right, what is that you have to answer? Go with the constitutional right. Then the other issue is with respect to linking Aadhaar with the birth records. For instance, attaching a medical officer's Aadhaar to any child born in the hospital or an SHO's Aadhaar to all abandoned children in their jurisdiction may violate these officers' right to privacy. So their right to privacy is also getting violated. And the other major concern is with respect to the facilities when death occurs. This is not covered in detail under this particular legislation. So there is birth, there is death as well. So with respect to the death, it is not covered rigorously, says this article. Added to it, the state government could decide that the cause of death should be issued by the medical practitioner who attended the deceased person. So there is a death of a person. So who will decide what is the cause of this death? So it has to be a medical practitioner. He goes to that particular place wheresoever the person has passed away, and he ultimately gives a decision. Or if the person has passed away in the hospital authorities will give it. But what if this medical practitioner happens to be a practitioner of Ayush? So we have the World Health Organization which has given a particular recommendation and has prescribed a standard. What if it is an Ayush doctor who is giving this certificate? Is it right? Is it in line with the international standards? May not be right, says this article. Further, the traditional practitioner may not have always arrived at a definite diagnosis before the person died. This has to be read with this as well. So what if a particular person is in hospital, is discharged from the hospital, it is because of particular diagnosis or because of something else as well. So a medical practitioner who comes to this area and he gives the certificate does not know what is the root cause of the person's death. He just gives the statement, what is death, and this person has passed away, but the root cause of it is yet not given. So it may also not be right with respect to the death, says the article. Fourth, while section 17 of the Act prohibits the inclusion of cause of death in any certificate issued under the Act, it now says that the cause of death certificate should be given to the relative of the deceased. There are contradictory, as the death in the death registration is taken from the same cause of death certificate issued by the medical practitioners. So there is a lot of confusion and dilemma and contrary provisions. So this has to be addressed, says the author. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is speaking about INS Vindhyagiri. What is this INS Vindhyagiri? This happens to be one of the important warships that India is coming up with. Just like its predecessors, INS Nilgiri, Udayagiri, Himgiri, Taragiri, Dunagiri, Vindhyagiri is named after a mountain range in Karnataka. We had the old Vindhyagiri, we now have a new Vindhyagiri which is in place. INS Vindhyagiri was a Nilgiri class frigate of the Indian Navy. Vindhyagiri was commissioned on 8 July 1981. Now this has been decommissioned, and now what we have is a new christened Vindhyagiri, which represents India's determination to embrace its rich naval heritage and also propel itself towards a future of indigenous defense capability. What we are looking at indigenization, what we are looking at is at Atmanirbharata when it comes to the defense capabilities. It is the sixth ship of Project 17A frigates. These warships are follow-ons of Project 17 class frigates, Shivalik class. It is equipped with improved stealth features, advanced weapons, sensors, as well as the platform management systems. The Project 17A ships have been designed in-house by the Indian Navy's Warship Design Bureau. This is very important from the preliminary examination point of view, a pioneer organization for all warship design activities, and this has 75% of the orders for equipment and systems of Project 17A are from indigenous firms. The launch of Vindhyagiri is an apt testament to the incredible progress our nation has made in building self-reliant naval force. This is important from the preliminary examination point of view. So remember these important facts so that you would be able to answer in your UPSC, KPSC and other state examinations. Now let's look into the next article. This article is speaking about one of the apps that has been designed by the Central Water Commission called as the Floodwatch. This happens to be an app which can forecast the chances of floods a day in advance. It also provides a 7-day advisory on the chances of floods at various stations in the country wherever the Central Water Commission maintains its measurement gauges. So we recently did discuss about the Uttarakhand floods. We also discussed about what is happening in couple of North Indian states where there is excessive flooding as well. So what is the root cause of these floods in Himachal Pradesh and Uttarakhand? We have discussed about it. We did discuss about the cloud burst. We did also discuss about western disturbance, so on and so forth. But the major problem with handling of the floods is we do not have enough data. So in order to overcome this, the Central Water Commission has come up with an app where they would be able to give information to the people one day in advance whether floods is going to occur in that particular place or not. So this is available on Google's Play Store. The app has a map of India with colored circles. What does it indicate? A green circle indicates it's normal, yellow is above normal, orange is severe, red is extreme. Clicking on the circle shows the current water level at the station, and this particular app is in 2 languages. One is in English, the other is in Hindi, and the key feature of the app includes real-time flood monitoring, and this app utilizes advanced technologies such as satellite data analysis, mathematical modeling, real-time monitoring to deliver accurate and timely flood forecast. With this app, users can access essential information regarding flood situation in the country. The user-friendly interface will make it easy for anyone to stay informed and minimize the risk during the flood events. These are some of the advantages that are associated with this app designed by the Central Water Commission. These are some of the important articles for today's Hindu newspaper. If you are liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. So this is it for today. Thank you for watching. All the best.